I call the member for Melbourne.
Thank you, Deputy Speaker. The reason that we are debating this bill in this parliament is because of two men, two Australians, Mr Nogen and Mr Pryor. Mr Nogen was and is a worker who suffers from cerebral palsy and epilepsy, and he worked in an Australian disability enterprise, is the term of art. He worked for a place called Challenge. One of the services that were offered by Challenge, in which Mr Nogen was employed, was secure document destruction. Not a kind of business that's limited to disability enterprises, but a business that is of the kind that you see generally in the office world. There were some other services that Mr Nogen was involved in, but that the enterprise offered, but they were offered on a fairly small scale. Now, Mr Nogen was asked to do a number of tests and tasks when he arrived that corresponded with some of the work that he did. He was asked to collate pamphlets, which involved inserting flyers into pamphlets, pen assembly, which involved fitting a ballpoint ink insert into a wooden pen casing, and feeding one crate of pre-sorted documents through a mechanical shredder. And the court found, and I'll come to the court in a moment, but the court ultimately said that these tasks were simple and repetitive and involved no element of decision-making. There wasn't any need to apply abstract concepts to the work that was being done, and the work was, in each case, work that involved simple physical manipulation of limited items. Mr Pryor, the other worker, who is the reason that we have this bill, was someone who was classified as legally blind. Although he did have some vision, he was also classified as having a mild to moderate intellectual disability. He worked for a different enterprise, and at the time of his first assessment under the test, the assessment tool that's the subject of this bill and that was the subject of the court cases, his time was split evenly between mowing lawns and some other general gardening tasks. At the time of his second assessment, 90% of his time was actually spent mowing lawns. So he was a blind worker with a mild intellectual disability who was mowing lawns. The other 10% of his time was spent raking and disposing of leaves, and he worked under direct supervision. Now, his effort, when he went to work, they timed him and assessed how good he was at doing this work. And it was found that he took 14 minutes to mow a 5 by 10 area metre of lawn, and his supervisor took 9 minutes to mow a similar area. So longer, but not even twice as long. And again, you can look at the task that he was performing, like Mr Nogen in the document centre, and see that they were relatively simple and straightforward tasks that they were required to perform. Then came the question of how much to pay these two workers, one of whom was mowing lawns, the other of whom is working collating documents, shredding documents and the like. And that's when the enterprises applied what's called the BSWAT assessment, the Business Service Wage Assessment Tool, which is the subject of this legislation. When they put them through that assessment and made them go through that tool, they asked them questions that bore no relevance to the work that they were doing. But it had a huge impact on them, because when they asked them some of those questions, and I'll give an example of some of those in a minute, these two intellectually disabled workers scored low, and in fact for some of them scored 0. And as a result, their pay was substantially cut. With Mr Nogen, for example, they asked him questions, like he was assessed as competent for everything, except they asked him questions like, what workplace meetings do you attend and what are these meetings for? I think that's something that everyone who works anywhere in an office in Australia probably asks themselves a lot of the time. But they asked him, and he couldn't give an acceptable answer, and so he scored 0 on the test for that part. And they asked him questions like, what are some other jobs that people do here? Again, not very evident in any way being related to the work that he was doing, but he couldn't answer that, so he scored 0. Mr. Pryor was also asked questions that he found difficult to answer because of his intellectual disability, but that weren't related to the mowing of the lawns that he was doing. So they asked him, for example, how can you help others at work? And he replied that he would try not to get involved, and apparently that wasn't a good answer, and so he was marked down. And as a result, Mr. Nogen, as a result of going through these tests and scoring 0 for a number of things that just weren't related to the work that he was doing, ended up being paid $1.85 an hour. $1.85 an hour for doing work for an enterprise that he, by all accounts, and including the accounts of his supervisor, was doing very, very well. It's just that when this tool was applied to him, it meant he scored 0 on a number of things and lost money, and same with the other worker. As a result, they very, very bravely took the matter to court. They took the matter to court believing that they were productive workers who were being massively underpaid, courtesy of a tool that the government had in fact approved. And they argued that it was unfair and discriminatory because someone who had an intellectual disability was never going to do well on that test and was always going to lose money, even though they could do the job very, very well. And in fact, Mr. Pryor, the lawnmower, at the time of the case going to trial, he had in fact left that job and was working at Stall Dry Cleaners, earning 5 times the wage that he had previously been earning. And the court, the federal court, and a full court of the federal court said, you are right. Said to these 2 workers, you are right. This tool discriminates against you, and this system that we have in place does not allow for you as a worker with a disability to be paid properly in accordance with your productivity. And in fact, by definition, especially if you have a worker that has an intellectual disability, you will end up being worse off. So they won. Now, they were 2 courageous employees with a disability who took on the system and won. And a full court of the federal court said, yes, you're right, you deserve to be paid more. Now, it takes a lot of guts to stand up and be the first ones to go through a legal challenge, but they did it. And they did it not just for themselves, but also for all those other tens of thousands of workers with a disability at the moment who also felt that they were being underpaid. Now, those workers have begun a class action to say, just like Mr. Nogen and Mr. Pryor, just as they got their just entitlements by going through the courts, so too are we entitled to do that. And this class action for 10,000 workers is underway. Now, it is because of that class action that we are seeing this bill. It is because the government now realises that if Mr. Nogen and Mr. Pryor were successful and were entitled to the basic principle of being paid in accordance with how good your work is, then perhaps all of these other workers are as well. And so in what is nothing more than an attempt to derail this class action and disadvantage up to 10,000 workers with a disability in this country who are hoping for justice, the government brings in this bill. The solicitor representing these employees with a disability calls this an abuse of power, and she is right. And what she says is that it will mean, for those up to 10,000 workers who have a disability, they are likely, if they're successful in their claim, to have their compensation and their payments, which is their wages, the wages for their productive work, cut by about half. In other words, this bill is being brought in to head off a class action being brought by up to 10,000 workers with a disability. Now, in that respect, I'm not surprised to see this government take action to ensure that workers and the most vulnerable of workers do not get what they're legally entitled to, like Mr Nogen and Mr Pryor did. But I must say I'm surprised that Labor is supporting them. I'm surprised that Labor is supporting the derailing of a class action being brought on behalf of up to 10,000 employees with a disability. Now, I hear some hope in the comments from the Labor speakers that this will go to a Senate inquiry and they'll have a look at it. At a minimum, if that Senate inquiry doesn't change their mind, at a minimum, when this goes to the Senate, given that Labor and Liberal are going to vote it through here, at a minimum, Labor should look at how to protect those 10,000 workers who currently have a class action on foot. Because otherwise, Labor will be responsible for saying to those 10,000 workers, you are not entitled to the same justice and victory that Mr Nogen and Mr Pryor got. Labor will be saying to them, those two got through the gate early and my goodness, a court said you were being underpaid and as a worker with a disability you should be entitled to payment in accordance with how you contribute to the workplace. Labor will be saying, no, we agree with the government that you don't have the right to your day in court and that you should be forced into a humiliating settlement of about half of what you otherwise might have been entitled to get. So it appears to be the case that unfortunately this bill will get through this House, but I'm not without hope, Deputy Speaker, that the process of the Senate inquiry and perhaps a moment's reflection will lead the opposition to understand that this is an unnecessary kick in the guts for up to 10,000 workers with a disability, at a minimum, let alone what it's going to mean for all of those who come afterwards. Because, of course, there is a place, and I think everyone in this chamber and in the other place would agree, without a shadow of a doubt, that we need to have a system at work that encourages employees with a disability to get into work and stay in work. And I think that would be universally shared amongst everyone. The question is, in this instance, with this bill, how much do you pay them? Do you pay them in accordance with their productive capacity and what they can contribute to a workplace? And do you say, how do you stack up compared with a worker who doesn't have a disability? Or do you say, we'll apply a test that allows you to be paid much, much less if you have an intellectual disability? Because that's what this bill is trying to get around. It is trying to erase the significance of Mr Nogen and Mr Pryor, who took courageous action to hold a government and their employers to account, and they deserve to be applauded and supported by this parliament. So does everyone who's involved in the class action who is coming in their footsteps on the basis of their significant decision. So, conclude, Deputy Speaker, by repeating it comes as no surprise that the coalition wants to take away the rights of low-paid workers, but I would urge the opposition to have a rethink before this bill passes the Senate and to choose to stand up for those workers who are currently seeking justice through the courts and seeking the same rights that every one of us would ask for, which is pay me according to the worth of the work that I do, not who I am.